Going on the record, State of Wisconsin versus Dquela Collins, case 25 CF 1634, appearances.
Matthew Tarbinson appears for the state. Good afternoon, Your Honor.
Attorney Abigail Ruckdashel on behalf of Ms. Dquela Collins. She appears in person. Good afternoon.
Cell phones, please.
All right, she's in person. Good afternoon, Ms. Collins. We are here for a sentencing following guilty pleas to 2 counts. 1, neglecting a child where the consequence is bodily harm as a party to a crime. That's a Class H felony. And count 2, straw purchase of a firearm, a Class G felony. I believe we're ready to go. Don't believe. I don't have any pretrial filings that speaks to anything, character letters or victim impact statements or anything like that. Is there anything I should have from the state's perspective?
No.
From the defense?
No.
All right, then I'll hear from the state first.
Going on the record, State of Wisconsin versus Dquela Collins, case 25-1534 mother, a 6-year-old boy, and a video sent at 11:28 in the morning. That video would become the last image of a child alive. But what the court would read into the record is a story not of an accident, but of a series of choices so casually destructive that they read less like a tragedy and more like an indictment of a culture that treats firearms like accessories. Before we go deeper into what the documents actually show, make sure you're subscribed to Beyond the Gavel file. Because we don't just cover the story, we follow the evidence. The court opens with the dry language of procedure. A guilty plea to 2 counts. Neglecting a child resulting in bodily harm as a party to a crime. Straw purchase of a firearm. 2 charges that sound like transactions. But transactions are what this case is really about. A transaction between a sister and a brother. A convicted felon named Quintel Collins, freshly released from extended supervision, and his sister Dquela, who the state would later describe as acting in concert with him to get a gun. The text messages recovered from her phone paint a picture that the judge would later call an absolute billboard of information.
Don't believe. I don't have any pretrial filings that speaks to anything, character letters or victim impact statements or anything like that. Is there anything I should have from the state's perspective?
No.
From the defense?
No.
All right, then I'll hear from the state first.
Your Honor, the state's recommending that the court sentence Ms. Collins to a term in the Wisconsin State Prison System of 3 years initial confinement, 4 years of extended supervision. On April 1st of 2025, Ms. Collins' 6-year-old son, Dquell, accessed a firearm. He possessed that firearm and used that firearm, ultimately resulting in a gunshot wound to his head. Just after 9:30 in the evening, Your Honor, the state's recommending that the court sentence Ms. Collins to a term in the Wisconsin State Prison System of 3 years initial confinement, 4 years of extended supervision. On April 1st of 2025, Ms. Collins' 6-year-old son, Dquell, accessed a firearm. He possessed that firearm and used that firearm, ultimately resulting in a gunshot wound to his head. Just after 9:30 in the evening, Ms. Collins' mother, Alicia Collins, discovered Dquell with a gunshot wound to the head. She immediately phoned 911. Emergency responders arrived on scene within minutes and attempted life-saving measures on Dquell's body. Those life-saving measures proved unsuccessful and Dquell was pronounced deceased on scene. Dquell was just 3 days shy of his 7th birthday when he died.
The child accessed a firearm. He possessed that firearm. He used that firearm, ultimately resulting in a gunshot wound to his head. Emergency responders arrived within minutes. Life-saving measures proved unsuccessful. Dquell was pronounced deceased on scene. 3 days shy of his 7th birthday. The prosecutor then said something that would echo through the entire proceeding: the death of Dquell was completely and wholly preventable. That word preventable would become the first turn of the screw. The defense attorney argued that losing her son was punishment enough. That prison would do nothing but damage the remaining family. That Dquela Collins had cooperated with police, provided the video, and had been working a double shift at a group home when she received the message. She was at work. She couldn't just leave.
I apologize for interrupting, but just to provide some further context, on page 33 of the police reports in the defendant's interview, she admits that she was at her boyfriend's house when she received the Instagram message at 11:28 in the morning, not at work. She also doesn't send or call her mother until 3 o'clock in the afternoon because her mother worked a double that day. It was her mother that worked a double, and her mother didn't get off of work until 3 p.m. So the first contact she had with anyone else in that residence, other than sending the single text message back to her brother, was her mother at 3 p.m.
The criminal complaint was murky. I appreciate.
She texted her brother to put the gun away. He sent back a laughing emoji. She called her mother. She went about life as if it were normal.
In some respects, I understand that Ms. Collins has suffered a great penalty already through her own conduct. When she received that video on April 1st of 2025, she sent a text message back to Quintel telling him to put her gun up. Ms. Collins also, according to what she told law enforcement, called her mother and asked her mother to address the situation. She had a video demonstrating the danger right before her. She sent a text message to someone who's completely unreliable and sent a laughing emoji back to her, and then sends a message to her mother saying, "Can you also take care of this situation?" And then went about life as if it were normal. She didn't take any additional steps to protect her child, to get those guns away.
But the judge, reading the text messages line by line from the bench, began to dismantle that narrative with the precision of a forensic accountant.
Whether someone's your blood family or not. And while it's true that as far as we can tell, Ms. Collins has complied with this court's orders, she acted remarkably recklessly with regard to her brother and the absolutely, positively cavalier way that she dealt with these guns.
Let's look at what those messages actually said.
And the two of you were talking about this. Is there any word on the heat? Nope. Just said shipped. As if it's the toaster you're ordering from Amazon. Is it here yet? Nope, just said shipped. Okay? You tell him to stop popping pills. And which is good sisterly advice. But you know he's apparently doing drugs. He says he doesn't want to go to jail. I don't know what it means when you say someone's coming with a gun and a broom. Maybe that's literal. I don't know. And then he says to you, March 20th, you can hold this gun until I pay you all your money if you want to after. Then you say, the next day, don't be leaving that gun anywhere in here because my son is steady talking about it. You knew he wanted to get his hands on it. You say, my gun came, and he says, I'll call you in a minute. Then you tell him, bring me my gun now. He's not supposed to have a gun. You know that. Did you ever get me some bullets? And he says, no, not yet. So you're using him to get you what you need for this in your mind. And he's apparently going to sell it for you. Somebody got $600 for your gun right now. Then he asks you if you want to make a quick sale, and you discuss reporting the gun stolen and then selling the gun. And he asks you for his clip back, and you give it to him. You say you'll give it to him. And when he sends you a video that shows him playing with the guns, your reaction is not to say, oh my.
In the weeks before the shooting, Dquela and Quintel communicated regularly about firearms. She asked him to help her purchase ammunition. She asked about the status of her gun order as casually as if it were a toaster from Amazon. Is there any word on the heat? Nope. Just said ship. She warned him not to leave the gun anywhere in the house, because her son was steady talking about it. She knew her son wanted to get his hands on it. She knew her brother was a felon. She knew he was not supposed to possess a firearm. And yet, she told him to bring her gun now. She asked if he ever got her bullets. She discussed selling the gun for $600. She even entertained reporting the gun stolen to make a quick sale. And when the video came, her reaction was not to call her mother in a panic, not to race home, not to scream for someone to protect her child. Her reaction was to tattle.
And when he sends you a video that shows him playing with the guns, your reaction is not to say, oh my God, my son is there. Mom, go make sure my son is safe. You tattle on him. Tell him to put my stuff up. In retrospect, I think your concern was for your son.
The judge articulated the horror of that moment with brutal clarity. He said, you didn't take steps to protect him. You wanted to protect your stuff. He didn't pay you for it yet. You wanted it. Stop touching my stuff. Whether he was going to pay you for whatever, the fact is this baby was there. The judge then posed a rhetorical question that reframes this entire story as a thriller, not just a headline. When your own brother sends you a video of himself playing with guns in the same room as your 6-year-old son, and you respond with a text message and a laughing emoji, what exactly are you protecting? That is the ticking clock moment. The moment where the ordinary becomes the extraordinary, where a working mother's routine becomes a criminal negligence that costs a child his life. The defense argued that you should be able to trust your family. That blood should mean something. That even a felon brother should be safe around his nephew. But the judge would have none of it. He said, you should be able to trust your family to protect your children. But when they send you absolute billboards full of information that says, I'm not protecting your child, you have to act. He repeated the phrase in his ruling, absolute billboards full of information. That is the moral refrain of this case. Absolute billboards of information, ignored. The judge sentenced Dquela Collins to 3 years of initial confinement and 3 years of extended supervision on each count, running concurrently.
I will sentence you to 6 years on count 1 in the Wisconsin State Prison, 3 years initial confinement, 3 years extended supervision. That will be concurrent to count 2. On count 2, I will sentence you to 6 years in the Wisconsin State Prison, 3 years initial confinement, 3 years extended supervision. I know I just said a bunch of numbers. That means 3 years in. That's the bottom line number for you right now. And that's 17 days credit will apply to both because of the way I've structured the sentence. I wish you well, Ms. Collins.
No.
3 years in prison, a sentence that both sides acknowledged was a fraction of what she could have faced. The state had reduced the charge from homicide. The prosecutor said she had already suffered the greatest penalty possible. She lost her son. But the judge made it clear why he could not grant probation. He said, the message does need to be sent to the world that this isn't just a suggestion. It's not just a yeah. If you feel like it, probably don't have a gun if you're a felon. No, you can't. He added, you knew that, and you entrusted your most precious resource to his care. You can't have this horrible combination of guns and caregiving and just hope nothing's going to happen, because nothing happened in the past.
We've lost all of the wonderfulness that could have been him. He could have grown up to be anything. He could have grown up to be a really hard worker like you and his grandma. He could have grown up to realize that breaking the law is not the way to go. And he was denied.
The judge's closing remarks are worth listening to carefully. He spoke of
She
a
left her
problem
residence
in
at
Milwaukee
1:30
County.
PM on March.
There are thousands upon thousands upon thousands of people who don't have firearms. Because I sit in this court, I hear from people day after day after day, well, it's dangerous out there, I need a firearm. You know what? That's not working for anybody. You are now among those who can never have a firearm. And I hope you respect that. You never have one again. Never be around them. Nobody is winning. No one in Milwaukee is winning by just getting more and more firearms. You're saying, oh, well, you have a regular firearm, so I'm going to get an extended magazine. Oh, you have an extended magazine? I'm going to get a switch. Like, it's just escalating beyond everything. Nobody.
Thousands upon thousands of people who don't have firearms. But those who do, he said, are locked in an escalating arms race. A regular firearm becomes an extended magazine becomes a switch. Nobody is winning. He told Dquela Collins that she is now among those who can never possess a firearm. He ordered a full mental health assessment, not because he believed she had a diagnosis, but because she would have to learn to deal with what she had done. The final question this case leaves hanging is not about guilt or innocence. She pleaded guilty. The question is about the nature of responsibility. The defense argued that Dquela Collins's part in the offense was small, that the real danger was her brother, that she was just a working mother trying to provide for her kids. But the judge rejected that framing. He said the text messages show she was absolutely all in on facilitating a felon's access to firearms. She wasn't a passive bystander. She was a participant, a straw purchaser, a sister who treated guns like commodities and forgot that her son was watching. The court docket for State of Wisconsin versus Dquela Collins, Case 25 CF 1634, is a public record. You can read the text messages yourself. You can see the timeline. You can hear the judge's words. And you can ask yourself the question that no courtroom can fully answer when we treat guns as accessories and felons as family members who can be trusted. How many more children have to die before we start calling it an accident and start calling it what it is? That is the question, and it deserves an answer in the comments. If you found this breakdown valuable, like this video, share it with someone who needs to see it, and make sure you're subscribed to be on the Gavel file with notifications on. We don't just cover the story. We follow the evidence.